All right, I'm going to get us going here. About 12:04. Looks like we've got a bit of a smaller group today. People will probably drop in in the next couple of minutes, but feel free to turn your cameras on here, and just want this to be sort of an interaction here with Jonathan Rizzardi here doing our presentation here of contract fundamentals. And we're following this up from a presentation we had last month, part one of this contract fundamentals, key provisions in owner architect agreements. Presented by Young Architects Forum here at the AIA East Bay. My name is Tim Nystrom, and we've got a great speaker today, Jonathan Rizzardi, who owns his own law firm. Thank you for joining us, Jonathan. Just want to give everybody a quick little introduction about yourself, and then I'll hand it right over to you. If anybody's got any questions, just some housekeeping stuff, if you got any questions during the presentation, feel free to put that in the chat, and we can get to it at the end. We'll have a nice Q&A session at the end here to talk about any comments or questions you have about the key provisions that Jonathan's going to go over today. But Jonathan owns his own law firm, Rizzardi Law. It's a boutique firm serving individuals and businesses and clients throughout the Bay Area. Rizzardi Law works closely with his clients to understand their unique circumstances and needs, and to craft and tailor an efficient and practical approach to anticipating solving problems. Rizzardi Law frequently assists clients regarding business information, licensing issues, professional service agreements, risk management, and dispute resolution, focusing a lot on architects and engineers in our profession. Our speaker, Jonathan, draws on over 15 years of experience in counseling, defending California professionals and their businesses. And he began his career practicing with a large firm in the city, San Francisco, before spending a decade honing his skills as a well-respected in a law firm, also in San Francisco, representing judges, attorneys, real estate, and design professionals and corporations associated with that. He graduated summa cum laude from UCSF, University of San Francisco, and from the Moritz College of Law at Ohio State. Thank you for joining us, Jonathan. Welcome.
Thanks, Tim. Thanks so much for the intro. I'm just going to share my screen here. And we should be good to go. I am, for those of you who were here for the first session last month, welcome back. Thanks for coming back. For those of you who weren't, I believe Sydney just posted in the chat the link to a YouTube video from the first session. I went through about 7 slides in the first session, more than 7, but 7 topics. I'm just going to touch briefly on those so we kind of know where we are. And then I'll get to topics 8, 9, and 10, and we can kind of dig into those in more detail. So let me just get my PowerPoint going here. So the first thing, just an overview. Really, this session is going to focus on a handful of key contract provisions. The last session, I also talked about the necessity of contracts and the recommendations for contract format, and I'll just hit those quickly here. First, does an architect need a contract? The major takeaway here is, in almost all instances, yes, I would recommend a contract. Under California law, there are only a handful of exemptions. You can see I have them here. And again, this is on the YouTube video from the last session. I went into more detail on this. But bottom line, in almost all situations, I would strongly recommend that you have a written contract with your client. Common problems with contracts. Really, the most significant issue I see here with clients coming to me with questions about contracts, or coming to me with a contract that they have, is that it's kind of a mishmash and it's not internally consistent, and that is very important in your owner architect agreement to have the provisions working together. So that's kind of the big takeaway on that topic. And then recommendations, there's many contract formats you can adopt. I recommend for, very generally speaking, for smaller size projects, residential or small commercial projects, I think a letter agreement with terms and conditions is a great approach. Really, as a matter of keeping your client, getting your client to understand the contract, client relations, not giving them a 30-page AIA document that's very difficult to understand. That can set a bad tone from the start of the relationship. If you are on a more involved project, maybe commercial project or more sophisticated residential project, I think the AIA documents are great. I use them very frequently. They provide really good templates, and I've listed them there in order from kind of most abbreviated to most complex. But just understand that you have to select and use the correct AIA document if that's the direction you're gonna go in with this, because there are AIA documents for large or complex projects that really wouldn't be appropriate for a smaller residential project. And that's something I see every once in a while, that it creates issues on projects. And then getting into the contract provisions, again, this is just a brief review. Standard of care, I think the takeaway here is to just be careful when you're, the standard of care provision obviously is critical. It's setting the standard that you're going to perform to. When you read the contract, if a contract is being proposed to you by the owner, pay special attention to the standard of care provision, but also to other provisions in the contract that may contain language which affect the standard of care. And I've got some of the key words there that you want to really watch out for. It may not necessarily be in the standard of care provision. There may be another provision that asks you to, guarantee, that can be common, or warrant that you're going to do or provide a certain level of service. So you need to be careful and look out for that. And then also be aware that the standard of care applies not only to your work product, but also to your timing. So something I see frequently is a time is of the essence clause. So just, be aware of that. Want to avoid that kind of language. Initial information and basic services. I think, just recapping, the goal here is really to be clear with your client what you are going to be doing and how you are going to be doing it. This is, I talked a lot in the first session about this being really a great opportunity to view it in kind of a positive light, as an opportunity to, mitigate your risk for the project, for the entire project. And it's kind of an easy one. It's upfront. Yeah, I mean, you're just communicating with the client about what you're doing. So often, though, I see this initial information is, very thin. I've even seen it not even filled out. And that's, that can really bite you on the back end. And then basic services, be specific about what you're including in basic services, because that can be a problem on the back end as well. I think, I don't know if it's in this slide, but, my, I guess, big picture advice here is define basic services in terms of what will be provided, and then everything else you're going to put into supplemental or additional services. That, I believe, is the B101 setup, and I think that's really the advisable way to go. And then, of course, basic services is where you're establishing the basis for your fee. So obviously, it's a critical section of the contract. And then just a few recommendations for initial information and scope of work. We're taking great care in defining basic services, but then sometimes I'll see provisions at the end of the section that'll say something like, any other services necessary to meet the owner's objectives or something along those lines, open-ended phrasing, and you've just kind of negated your strong scope of work provision. So steer clear of that. And then, of course, I think most of you probably have experience with this. The CA phase is an area where basic services can often be abused. So, be careful to limit your obligations with respect to site visits, submittal review, that observations of work, and make anything beyond the limit an additional service. Same thing for project completion, kind of same feel. Got to be careful that you limit your time frame there. And then an integration clause, including a clause. This is kind of more on the legal side, but this agreement is the agreement. There is nothing that's going to change that in terms of something we discussed 6 months ago, prior proposal, prior negotiations, etc. Supplemental and additional services I'm going to skip for purposes of this. Again, you can see this on the YouTube video and right to rely. We talked quite a bit about instruments of service and copyright. I remember mentioning that this is kind of getting into the provision where I see a lot of confusion amongst both architects and owners. My advice here to architects, kind of thinking big picture, is, what I see very commonly is just architects not taking seriously enough the value of their copyright and their instruments of service. In other words, this being an area where they might forfeit, their rights with respect to instruments of service and copyright, thinking, they need to do that to get the job. Of course, if that's something you need to do, by all means, but a lot of times I just see this kind of glossed over and quickly kind of dismissed, like, well, I'm not going to do a project that uses this design again, so it's no big deal to give that up. But there are important rights that you need with respect to instruments of service and copyright that I talked about in a lot of detail in the last session, including, just as a default, protecting yourself from, the owner using your design in the future without your authorization. So it's important to just be cognizant of those issues and understand that your copyright, your instruments of service do have a great deal of value. That's your value. And that's something that at the very least should be used as, a bargaining chip in terms of the contract negotiation process. And then limitation of liability. We talked about this in detail. I think the most important takeaway here that we discussed was understanding the appropriate limit for liability in terms of the amount. And I talked a lot about using available insurance proceeds rather than insurance limits or your fee, although your fee might be an appropriate limit in some circumstances. Available insurance proceeds is a good way to go because it signals that only the insurance proceeds that are available from your insurance policy, in other words, proceeds that haven't been, in other words, the insurance amount that hasn't been run down by defense costs or by another claim, will be available to satisfy liability. And then we also talked quite a bit about consequential damages. I explained, the meaning of the term, and they are frequently negotiated with limitation of liability clauses, and that they relate to one another, and the importance of essentially getting one or the other. Because, obviously, if you can't get a waiver of consequential damages, then that limitation of liability clause, the importance of that is heightened, and vice versa. So that's just a kind of a brief background of where what we did on the last session. And then now we're getting into new territory that we couldn't cover the last time around. So again, if you would like to see the last session, I believe it's been posted by Sydney in the chat. So turning now to our new material, the first topic is indemnity. And, similar to copyright, this is one where I see quite a bit of confusion from both design professionals and owners. For purposes of this presentation, I'm just discussing owner requested indemnity. Of course, architects in some circumstances can also get indemnity, but that's a separate issue. However, the concepts are, of course, similar. So, but just approaching it from owner requested indemnity, because that's what I see more commonly as the issue dealing within contract negotiations. So, owner requested indemnity is basically the owner seeking coverage for claims by a third party relating to the architect's services. And it raises two main issues. First is the duty to defend. So, the owner gets sued by a third party. The architect's alleged negligence is somehow implied in that suit or that claim. And what is the owner asking the architect to do? The first is potentially to defend. And a duty to defend arises at the beginning of the claim upon an owner's request that the architect tender a defense to the claim. So, the owner's attorney would typically send a tender letter saying, you are required to defend this claim because it involves your alleged negligence. So the issue with that is that under California law, an architect that agrees to indemnity takes on a separate duty to defend automatically unless a contrary intent is expressed in the contract. So in other words, if the contract just says that the architect has a duty to indemnify, then, unless it's disclaimed by the architect, he also has a duty to defend. So indemnity includes defense. There are some recent changes in the law that soften that somewhat, but I don't think you want to, leave it up to that. You need to, as we'll discuss, kind of take action to make sure that you're not being hit with a duty to defend. The second issue is the duty to indemnify, and that arises at the end of the litigation or claim upon at the end of the litigation. If you have an adverse judgment against the owner, the architect is required to pay some portion of the judgment. That's indemnification. So recommendations, and I've kind of broken it down into 4 issues to look out for in an agreement that an owner is proposing to you. The first is the owner trying to impose a duty to defend. So the owner sends a contract, it has an indemnification provision, and maybe it says that you have a duty to defend, or it just says you have a duty to indemnify, and it doesn't expressly disclaim the duty to defend. That would mean you have a duty to defend. What's the problem with that? The main problem is that a duty to defend, the owner is not insurable under your E&O policy, most likely. And that's because your E&O policy is designed to protect you from, it's designed to protect your provision of services for the benefit of yourself and your firm. So, your insurer is not protecting anyone else other than you and your firm. So for that reason, the duty to defend has to be carefully, you got to review that provision. And if it's in there, it's got to be stricken. And if it's not in there, there's got to be a provision that says, you're not defending. The second issue is the owner trying to get you to indemnify an overly broad class of indemnities. So not just the owner, but also terminology like agents, subsidiaries, related parties, subcontractors. I mean, the list could go on. And pretty soon, you're indemnifying everyone on the project, everyone related to the project, et cetera. So you've got to be careful to limit the indemnities as much as possible. Third, unlimited exposure regardless of fault and exposure for matters outside of the architect's negligence. So again, this goes back to an insurance issue. A professional liability policy generally is only going to indemnify for damages arising out of your negligence. It's not going to indemnify for contractual liability. So that's why, got to be careful there. And then finally, limitation on the indemnity obligation. So, owners will typically not have any kind of limitation. So you've got to look out for that. So what should an indemnity provision look like, ideally, taking those four concerns into account? And I've got one here. This is kind of a model indemnity provision with the four issues that we talked about in bold. So the first, architect shall indemnify the owner and the owner's officers and employees. So, that's addressing the kind of a limited scope of indemnities. We're not indemnifying everyone on the project. We're not indemnifying, agents, subsidiaries, et cetera. We're indemnifying owner and owner's officers and employees, which is a kind of defined scope of indemnities. And then you're indemnifying only to the extent the damages are caused by the negligent acts or omissions of the architect. So again, that's a matter that's covered under your insurance policy. It's not indemnifying for contractual issues. And then the next bold piece, it does not include a duty to defend. So you're not defending the owner here. You're just indemnifying. And finally, the architect's duty to indemnify the owner shall be limited to the available proceeds of the insurance coverage. So this goes back to the limitation of liability we covered last time, but you're limiting your indemnity obligation to the available insurance proceeds. So next topic, suspension and termination rights. And the question here is, what are the architect's options in the event the owner does not timely pay? Huge issue. Obviously, the architect needs to be paid. They're not working for free. So the contract has to address that situation. And I have here a three-part termination and suspension clause. So the first to make clear is that failure to make payment is a material breach and cause for termination or for suspension of services. So, one or the other. It can just be, both, but it's a material breach, and the architect has the option of either saying the contract is terminated or to suspend services. And typically, and this is kind of the B101 setup as well, there's a period of notice before the termination or suspension. So the AIA, I believe, is 7 days. And it should clarify that the architect doesn't have liability for any damages, delayed damages or otherwise during that period. It should make clear that the architect has to be paid in full, as well as be paid for expenses incurred in connection with interruption and resumption of the architect's services before the architect can resume services. And then if the architect elects to terminate for cause, or the owner doesn't cure, the architect has to be compensated for services performed and for reimbursable expenses incurred prior to termination, as well as for termination expenses. Particularly on a large project, an architect might have significant expenses incurred with respect to termination. And then going back to the copyright issues we discussed last time, any owner rights as to the instruments of service have to terminate. So the owner no longer has the right to the copyright or the instruments of service, depending on how you have that set up. So some recommendations here. Frequently, I see provisions that haven't been negotiated, or have, and for whatever reason are still in the contract, that the architect is obligated to continue to provide services regardless of payment. Or sometimes a more common one is despite non-payment of disputed sums. And that can be a real problem, and I have seen it become a real problem because the owner might not be reasonable in terms of what a disputed sum is. They might just be disputing everything at that point. So try to avoid those provisions. Those can be really problematic. And then the architect's payment period has to be reasonable to begin with, because that establishes the time frame for attempting to obtain a resolution. So I saw a contract not long ago where the architect had allowed the owner to put in a 60-day payment period, and that was a huge problem because it was 60 days later and payment still wasn't being made. So you're not really leaving yourself any leeway there. And then only after the 60 days can you get into kind of the whole dispute resolution period. So that's a real problem. And then, of course, considering the consultants before suspending services, depending on how the contracts with any architectural consultants are set up, what will be the impact on the consultants if the project is suspended or if the contract is terminated. That also has to obviously be taken into account. And then the final issue is dispute resolution. And this is one that, I've spent a lot of my career doing litigation. And so, seeing this from the other side, once you're in litigation and how the parties handled the dispute resolution provision, I think it's a provision that the owner and architect don't often spend a lot of time on. But once you are in litigation or arbitration, you look back on that, and frequently there's some remorse as to how it was handled. So it is a very important provision. And of course, the goal is to clarify the course of action in the event of a dispute, whether during the project or following project completion. What I recommend is that you have a period of informal negotiation. It can be 30 days. If that doesn't resolve the claim, a mediation. And if it's not resolved by mediation, you can choose between binding arbitration or going to litigation in superior court. A few recommendations here. The 30-day period of informal negotiation, that's pretty early on in the dispute. I would, however, recommend that you consult with counsel during that time frame before you start sending off, communications or letters to the owner, because those communications will be front and center if the case doesn't resolve during the informal negotiation period. If you end up in litigation down the road, what you said during that initial back and forth can really come back to bite you if it's not, if you're not careful. So, and then mediation, very, very common now. One thing to point out, oftentimes your insurer will give you a credit for resolving a claim in mediation. So that can be an incentive. Usually it's like, your deductible gets cut in by some percentage. So keep that in mind. And then the difference between arbitration and litigation is always an important consideration as well. There's pros and cons to both. I think typically I end up recommending arbitration with the idea that it is, slightly more cost effective and less time consuming. And it's also an informal process, which can be easier a lot of times for clients. An informal process meaning, you're not in court, you're in an office, but it is something that you need to really think about and consult with your attorney about. And then, of course, the dispute resolution provision must survive termination of the agreement, because often, disputes will come up after the project is complete. And then finally, just a few things to look out for in connection with dispute resolution. Choice of law and venue provisions, setting law or venue outside of California or outside of the area where the county where the project took place. We really want to keep the applicable law as California law if the project is in California. Any attempts by the owner to limit the architect's recourse are important to take note of. And then finally, prevailing party attorney's fees provisions. This is a provision where the parties agree that the winner is entitled to recovery of attorney's fees. It's problematic because it's a contractual obligation to pay. So if you lose, it's probably not insurable. And, even if you win, if you're insured, you're probably not getting that money. So generally, I recommend that the prevailing party attorney's fees provision be stricken from the contract. And I think that is all I have for this session. Let me go back to stop sharing.
Well, thanks, Jonathan. Yeah, great way to end part two. 3 provisions that we didn't get a chance to, or 3 key components that we didn't get a chance to get to last time. So thank you for that recap, and coming into the 3 new key components.
Yeah, absolutely.
The rest of it. That was awesome. Yeah, appreciate it. We're going to open it up to the floor now. If anybody's got any questions, comments, or things you want to go over, clarifications from the information you heard today, feel free to go ahead and see if I got any. I know I had a couple. I'll just go ahead and ask my questions while maybe
Sure.
some people are looking for an opportunity to ask something. So the 30-day informal negotiation process. So you had mentioned that this is a key area where architects need to be sensitive to the dialogue they're having with their clients or the contractor, whoever they're trying to informally negotiate with. But as architects, a lot of times we want to avoid conflict whenever possible and try to give the owner or the contractor, ample time to make a decision or make a payment. So what other kinds of more specific recommendations might you have for an architect that, as introverts, we don't like to go out and get right in somebody's face about, hey, why haven't you paid me? Email seems to be a great way to get our thoughts out there without really having to, interact with anybody. But like you said, that could really come back to bite you in the end. Are there any tips or tricks that you've gotten or that you can maybe recommend for that process?
Yeah, so I mean, I could do a whole presentation on it, but it depends on what the claim is. So let's set fee disputes aside. Let's set aside the issue where the client's just not paying and you have to hound him for that. Let's first talk about the client's saying you did something wrong. There's a design error. that's one that unfortunately comes up from time to time. So the reason I picked that is at that point, you want to most likely report that to your insurer. I mean, that's what I would recommend as a claim. And your insurer can get the process going of assigning counsel. I mean, you can, of course, reach out to, your whoever you typically work with as an attorney, and I would recommend doing so. But your insurer can also get the process going. And the reason that's important is there are often, from an insurance perspective, time limits on, the amount of time you have to report a claim. So that's one thing to think about. The other thing is, in that same situation where the client is saying, look, you did something wrong, and I recommended that you reach out to counsel. It's not necessarily that you want to, start the whole process of, I got my lawyer, you got your lawyer, we're going to war. What I see a lot of times that's a problem is, I get the case when the client has already engaged in back and forth with the, or the architect has already engaged in back and forth with the client. And the architect has said some things that may be problematic, like maybe they've made some problematic admissions that they, missed something along those lines. So the reason I, as a lawyer, want to kind of get ahead of that is, I can advise on how to kind of structure that response or that initial letter. And it doesn't always come from me. It might just be, okay, client, architect, you write it up and then I'll take a look at it. It doesn't have to be a, time consuming or expensive process, but just have somebody take a look at it for you so that, you make sure you're not going to get into a problem on the back end. And then, so, if you have a fee dispute where the client's just not paying, I totally hear what you're saying. You don't want to hound them. And I don't have any, great recommendations on that. I mean, that's always kind of a case by case basis in terms of the, the situation. But the problem can be that once you send out that, pay me letter, the client comes back and says, well, wait, you didn't do this, you didn't do that, you did this wrong, so now you're in the world of, oh, wow, we've got a real claim kind of going in both directions. So in that situation, I'd also, advise you to reach out to your attorney and figure out a way to, strategize on best way to, communicate with the client on that issue. But, in terms of, we talked a little bit about the termination clause, suspension of services. I mean, once the client stops paying, you're right, under the contract I'm kind of recommending is to suspend services. It's a little bit harsh to say, you didn't pay me on time, so we're terminating, of course, but maybe there's some ways you can say you didn't pay me on time, so, we're going to have to suspend our services if we don't receive payment within, 14 days from now or something along those lines. Just kind of trying to take everybody's interests into consideration, rather than, going all legal, going lawyering up and going to battle, because that's never usually a productive idea. And, from my perspective, having litigated cases for a long time, I always am trying to avoid going down that road, because nobody ends up winning in the end. So.
Right. Yeah, no, I think that's something we all try to avoid whenever possible. Getting lawyers involved, and the thought of that sometimes scares people just because of cost and time and all those kinds of things. And you talked about the termination, and then just one quick follow up to that, you talked about the termination clause, and If that isn't in a contract that you currently have, or maybe you had a situation in the past that didn't include something like that, is it right to threaten, because we're such a service, oriented business here, to say, hey, I'm not going to give you the drawings, or hey, we're not going to submit for permit until you pay me? Do you ever see that happen where you can, use your instruments of service as leverage to get payment? You recommend going down that road in terms of, what an architect can do with what you got in order to resolve these things?
Yeah, well, it depends on what the contract says, of course. If it doesn't say anything, the default is that you are the owner of the instruments of service. So, I would expect the contract to say something about that. But if it doesn't, you do own that right. So, again, kind of a difficult situation to say, look, I'm not going to give you, I'm going to hold back. But maybe there are times when that's appropriate. Yes.
Yeah. Anybody else have any questions for Jonathan? This is a great opportunity to speak one-on-one with an attorney who's been doing this for a long time and has many hours and years of experience here, addressing some of the concerns everybody, all architects and engineers have. I did have one question in the chat about the slides. I don't know if your instruments of service, your documents do you think those will be available for everybody, or should we just keep it to the video? What are you comfortable with, Jonathan, in terms of?
So the video will be posted, I assume.
Yep.
And you can see that on the video. If you want to reach out to me, if you have anyone has any questions, or needs any kind of advice, of course, please feel free to reach out, and I'll make myself available. Awesome.
Thank you. Well, thank you, everybody. Any going once, twice? Oh, we got one coming in here. What is the quote unquote counsel to seek help? Is it the attorney?
Yeah, when I say counsel, sorry, I'm not consistent. I just mean your attorney, your legal counsel, or your attorney, or your in-house counsel, your lawyer. Those are all, all interchangeable.
Cool. All right. Well, yeah, thank you again, Jonathan. This was a great follow-up, part 2 to the part 1. Again, as we had talked about many times here, the videos for both of these sessions will be available for anybody who maybe came in a little late or maybe didn't get a chance to get here for part 1. But thank you again for making yourself available here. This was extremely informative. We love to have people like yourselves involved with young architects, emerging professionals, young, small firm owners that are just really kind of getting started and have some concerns about a topic that doesn't get discussed enough in school, for sure, and definitely as we grow in the business of architecture. Just contracts and the provision, the key components of contracts, because it really saves us in the end if we can have a great contract and an attorney like yourself behind us. Makes our lives a lot easier. And so thank you again for the information you've given us.
Yeah, absolutely. My pleasure.
All
Thanks,
right.
everyone.
Thank you, everyone. Have a great day, and look forward to next time.
All right. Thanks, guys.
All right.